Good afternoon, Your Honors. The matter before the court this afternoon is the case entitled Grant Taylor and Richard Scheiber versus the Town of Cabot, the Cabot Community Association Incorporated, and the United Church of Cabot Incorporated, docket number 2016-276. Representing the appellant, the Town of Cabot, is Stephen Codius. Seated at counsel table with Attorney Codius is Daniel Richardson. Representing the appellees, Grant Taylor and Richard Scheiber, is Hannah Trudeau. Seated at counsel table with Attorney Trudeau is Grant Taylor.
Counsel.
Good afternoon, Your Honors.
Good afternoon.
I'd like to focus on two main points today. First, I'd like to say at the beginning that we just represent the Town of Cabot. Other defendants that are listed, we do not represent them. The plaintiffs here rely solely on
And they have not
taxpayer-
filed, they've not appeared in this
Not in the
portion
appeal.
of this case.
That's right.
Okay.
Yeah. Plaintiffs rely solely on taxpayer standing, but they have not shown any injury to themselves as taxpayers. That's my first point.
Can I ask you about that?
You can.
The Town of Springfield case.
Yep.
I realize there's no analysis of the conclusion that taxpayer standing existed there, but it
unfortunate.
seems to go further than what you've just stated by saying a potential wasting of town assets is enough.
So I think I'd like to break that case down a little bit. And the test for injury in fact that comes out of that case is you have two things. You can either have a direct loss to the taxpayer, or you can have a waste of municipal assets. Now, I think that this is dealing with harm that has already happened, a direct loss, or in the case of waste of municipal assets, exposure to taxation in the future. So this is a potential liability to taxpayers. And there's nowhere in that decision where the court jettisons the requirement of financial harm. And this is the basis for municipal taxpayer standing. This is what the doctrine is based on. And I think
But isn't the money here a municipal asset?
the money here is not a municipal asset in the sense of taxpayer money. And so
Well, wait a minute, let me see if I understand that distinction. So it went out according to an existing program, but it went out for a loan.
Yeah.
It came back. It is money in the account of the town. It is owned by the town. It's town money, is it not? So how do I not call it, if it's town money, a municipal asset?
It's because it is not generated through taxation, and this is why there is no
But the
connection.
test of Springfield doesn't say it has to be generated by local taxation. It just says it has to be a municipal asset. So if somebody gives the town a building, didn't happen by taxation, and they give that building to a church, would your argument be, oh, there's no standing because it came to them for free?
There would not be municipal taxpayer standing, no. I think that the important point that comes out of Springfield is that the money there that was not out of taxpayers' pockets was through the Federal Revenue Sharing Act. And although Springfield did not go as far as to analyze what that statute did, it cited to a few cases that actually did discuss that. And one of those is the Matthews v. Massel case out of Georgia. And there the court went through this analysis and said the taxpayer can only have standing if they can show some exposure to taxation in the future, now or in the future, and went through how the Federal Revenue Sharing Act works and said if there's a violation of that act, the town is liable to repay funds plus a penalty, and there's no other place that those monies could come except from the taxpayer fund.
So
And
let me go back to my church hypothetical.
Yep.
The town has the money, has the property, right? It chooses to give it to a church. Is there no one then that could stop that? It's entirely a ballot box issue. Give new selectmen. The town at will can simply give a large asset of the town to a church without any way of anybody to bring litigation about that.
Well, there could be alternative routes. There would not be municipal taxpayer standing based on the
Yeah, but what alternative?
scenarios.
I don't see an immediate alternative. What is it?
Right. I mean, one thing could be is that if it appears to be, particularly egregious violation of the Constitution, can bring it to the state attorney general to pursue it on behalf of the public. But, as a matter of taxpayer standing, that is the only thing that the plaintiffs have alleged here. That is simply not enough.
Do you concede if they had made a First Amendment challenge under the federal Constitution that they would have standing?
No, I do not concede that. I think there is an important point to make here in that there are different silos of standing under First Amendment jurisprudence. So you have direct exposure standing if there's, a cross on a firehouse or, you have a crush on the City Hall steps, right? The plaintiffs are directly exposed to governmental speech which has a religious element. But that is completely separate from taxpayer standing. Now, there is the narrow FLAST exception for First Amendment standing, but the court has made clear that there still must be a connection between the taxpayer's wallet and the actual harm that occurred.
But the taxpayer here is arguing that but for the distribution of these grant fund pot of money to the church would have to pay for it themselves. And then with the town voting to give the church the money for the repairs, the church then has more money to spend on its own promotion of religion.
So I understand the multiple steps of that analysis, but frankly, that's speculation. None of this is in the record. The plaintiffs presented no evidence whatsoever below. There's no evidence that taxes would be raised in order to displace these funds. There's no showing that the church is unable to repay these funds in the future. The trial court specifically made that finding, and that has been shown to be a sufficient remedy in these types of cases. In the American Atheist case out of the Sixth Circuit, the court there found that ordering one party to repay the funds was sufficient. And it would be speculation to say that, if these funds are granted, then someone else doesn't get funds, and then somehow the municipal, taxpayer money is going to be spent on a project that didn't get a grant. I mean, these are exactly the type of speculative injuries that this court and the Supreme Court have not found to be sufficient. It's just, there just isn't a concrete, particularized injury in fact.
Of course,
So-
this is money that was created by taxation. It's just
Federal
not-
taxation.
Yes,
Yes,
right.
and so I don't
why
think
does
that-
that matter?
So I don't think that a federal lawsuit is precluded here, but
No,
we're,
why does it matter that it's federal taxation rather than local taxation with respect to standing against the town?
because there are different pots of money. The federal money, you pay federal taxes, they go to the federal treasury, and, then there's an appropriation, money gets passed around through. There's no connection between the taxpayers of Cabot and,
Well, they paid taxes. I understand it's a little less direct than it is with respect to a Cabot expenditure from taxation.
right.
But nonetheless, they paid taxes, and what's happening to their tax money by this unique little device of going in and out of a program is that it's ending up going to a church.
So,
What is the difference between federal taxation and local taxation for this purpose?
So I would say that the FLAST exception for federal taxpayers has been severely limited, and the Supreme Court has gone so far as to say that if it's an agency spending the money, for example HUD, like HUD did in this case, then there is no federal taxpayer sitting to challenge it. It's not, it doesn't come out of the Congress's taxing and spending power.
And I understand, we're not suing HUD here, we're suing
Right,
the town.
right, but that's precisely why the connection is too fragile, it's too tenuous. There's just not enough to show that the taxpayers' dollars here are the ones that ended up going to the church. So I'd like to just move on to the merits here, because I think that there's a really important point that the trial court really misconstrued how these grants are administered. So the trial court essentially looked at the town meeting warning, which is a notice. Of course, it's going to be vague. It's a summary of what is, this grant money is for. But the trial court looked at this and said, that's too vague. If the church is given a pot of money with just those restrictions, that would allow it to do anything. It could fund a strictly religious element of the church. But that is not how these grants are administered. First, there's an application by the grantee. It's very detailed. It explains what the funds need to go to, what repairs are necessary. And in this case, the church submitted an application that included a conditions assessment, which I would note was prepared by the Preservation Trust of Vermont with state monies. This is from the Division of Historic Preservation. This is a historic preservation project. And the grantee, the church, submitted this application. The committee, the UDAG committee, vetted this. And then there is not just a lump sum given. Afterwards, pursuant to the UDAG plan, which is in the printed case here, the committee then looks over and reviews every invoice as it comes in and makes sure that it complies with the application as the money was applied for. And if it deviates from that, the committee has the power to not give the money.
And am I correct in understanding that what was applied for was windowsills and exterior paint?
So that is a major part of it, and I think that what the trial court had trouble with was this portion of the town meeting warning which said other interior sections.
No, I'm not
Oh,
looking
you're
at the
putting
town
that-
meeting warning, I'm looking at the grant. If the grant is awarded,
Yep.
it's going to be defined by the terms of the application. So I want to look at that and know
Yeah.
exactly what it is that they're supposed to be doing under this grant.
Right, so the conditions assessment outlines a number of exterior repairs, and as far as, it's a lot of paint, it's siding, it's, there are, repairs to the bell tower, stairs, and as far as interior sections, which I think the court had trouble with, there are a couple things mentioned, which are cracking in the plaster, there's some insufficient insulation, and these are all structural elements. These are makes the building safe for everyone to use it.
So you're talking about the conditions assessment, but what I'm looking at is the actual grant application.
Which does include the conditions assessment by reference.
Okay, it references them, but all I see is we are seeking funding to help with completing the painting of the main part of the building and exposing and examining the other sills for damage. And the timeline for implementing and completing only talks about painting and sill examination. Are you suggesting that in fact the potential use of the monies is greater than that because anything that's in the conditions assessment is fair game?
I do think that what is in the conditions assessment is fair game.
Okay.
It seems to me that it is incorporated by reference, but I would note that there are no strictly religious elements in there, and I think that the Preservation Trust with state funds took care to make sure that this was a historic preservation project and not something that was going to support actual worship, which is the test that we're looking at here. I'd like to reserve the rest of my time for rebuttal.
Okay, thanks. Counsel?
Good afternoon, Your Honors.
Good afternoon.
In March 2016, the Town of Cabot approved the use of $10,000 of town money to support the United Church of Cabot. This raises a simple question. Can a town support a church? And I believe the simple answer is no. There are more nuanced questions, some of which the appellant raised. Chief among them is there a distinction for standing purposes between taxpayer money and grants from outside sources. I would say that Springfield, which is the only Vermont case that I was able to find, and I believe was discussed at the trial, that the Judge Tomasi and the town was also able to find, controls. Springfield dealt with federal tax revenue sharing money. It was not directly out of the pockets of the residents of the town, and standing was still found in that instance.
But the analysis on the standing from the Springfield case is a bit sparse, wouldn't you agree?
Yes, it is. It cites McQuillan, which, as the town's attorney laid out, sort of allows for two alternatives, which is that there is a direct loss or that there is a waste. If an unconstitutional expenditure is not a waste of money, I'm not sure what would be considered as such. I think under that prong of the Springfield analysis, you have standing here. There are also decisions out of other states that have similarly found standing beyond the sense of the pocketbook action.
So I had trouble when I looked at Springfield, but squaring it with our statement as recently as the Turner case that we follow the federal law on standing. And the federal law on standing has greatly narrowed taxpayer standard and doesn't have this waste of assets part of it, does it?
In Turner, I don't believe that there was that level of discussion.
No, Turner's the most recent one, but it points out that we have, on a couple of occasions, and I won't recall tracing back all of them, but we have said we follow the federal law on standing. That very general statement, and the federal law on standing, it seems to be more narrow than Springfield says. So when that argument was made by the appellant, you came back with Springfield. You said, no, we follow Springfield. But Springfield doesn't appear to be consistent with the federal law on standing, does it?
Federal standing law is murky, especially in the context of First Amendment, which is one of the reasons that we chose to bring this under Article 3 and focus on Vermont, because it has been something with the Establishment Clause sections that has changed a pretty substantial amount in the last several decades. I don't think that there is a uniform application across the board, across all states, where you can say that it is only a pecuniary, more specifically even than that, direct out of the pocketbook of taxpayers where standing lies. There can imagine too many instances where there would be no one that would have standing unless you were going to the attorney generals of states in that instance, and that just doesn't seem like it would be the pragmatic intention of that sort of those types of holdings. The Article 3 of the Vermont Constitution also says no person ought to be compelled to support a place of worship. In that sense, it's not talking about taxpayers. I think that taxpayers standing...
So I'm not sure you made that argument in your brief, or below. So your argument is that there's a different standing rule depending upon which constitutional provision you're enforcing. So there's a special one for religion under the Vermont Constitution?
Well, you have a constitutional violation here.
I know we aren't at that stage, of course, about constitutional violation. We're not just talking about the standing question of it. And I guess the second was the temporary relief. But right now we're on standing. So what I'm trying to understand is there a separate and different rule for standing for religion-based claims in the Vermont Constitution as opposed to speech-based claims or some other kind of place? Is standing different?
That I know of, there is not a fast analog, as it were, in Vermont jurisprudence, if that's the answer to your question.
Well, you cited the language of the constitutional provision with the suggestion that it contained its own standing requirement. That would suggest there's a different standard than for religion-based claims on the Constitution. No? Did I miss what you were saying?
No, I There is not on the books, but for the same reasons that there is the last exception lies at the federal level, I am comfortable with the idea that religion as primary and one of the most fundamental civic rights allows for a wider interpretation than pecuniary pocketbook injury. It's an injury to the taxpayers, the citizens, the residents, whatever name that you'd like to give them.
So your argument ties in part, even though it's municipal taxpayers standing, it ties in part to the particular constitutional provision at issue. If the argument here were that the expenditure of monies from this fund violated some state regulation, are you saying different standing analysis in that circumstance?
I'm not entirely sure, because I would, trying to imagine the different scenarios, if something in that instance would also be brought under the First Amendment, and then unfortunately, you're merging the two areas. But if I can return just to the language of Article 3, it's no person ought to, or if right, can be compelled to attend any religious worship or erect or support any place of worship. There's a distinction drawn, it also goes on to maintain and minister. There's a distinction drawn between the attendance of worship and support of a place of worship. In the Chittenden case, the court came to the conclusion that compelled support, it's not really such unless it is compelled support of worship. That case was a different context. It had to do with a school and whether tuition payments to that school, which was owned by the Roman Catholic Diocese, violated Article 3. And ultimately, the court was unable to distinguish between religious education and religious worship. The difficulty in that case of making that distinction, I think, is even more difficult here when we're trying to distinguish between religious and non-religious parts of the church, if that's even possible.
Isn't that a pretty broad reading of the Chittenden case? I mean, couldn't an argument be made that that case actually turned on the lack of segregation of the funds that were received, and that it could have passed constitutional muster if the funds that were used to support the worship had been segregated from the other funds?
It certainly doesn't dismiss that part and left open the possibility that if there were more precise guidelines, then perhaps it would have passed constitutional muster. I think that some of the ambiguity here of even whether it's the warning that was put before the Town of Cabot, whether it's the application, whether it's the HUD rules, even which of those is the controlling thing, you've got the same problem in this instance, is that there's too much ambiguity to know even where this money is going to be spent.
So is it your position that the grant monies that may have come from the State Division of Historic Preservation for the purpose of fortifying the same structure, which includes both community functions and worship, is also unconstitutional under the compelled support? I know that's not the case you're bringing, but are the implications of your argument that that's also unconstitutional?
I think there's certainly that possibility. I think anything in this area is going to be very fact-specific and is going to hinge on the specificity involved. You've also seen that in the American Atheist case, which was about the revitalization of Detroit ahead of the Super Bowl, and they opened up money to basically any building within a specific geographic area to have repairs made. But it was a much more heavily regulated, neutral set of guidelines that were controlling. Here, the Cabot Community Investment Fund, one of their chief guiding principles is just that it's fair and consistent, and I just don't think that that goes far enough towards partitioning off or earmarking where these monies would go.
So you would suggest that the federal regulatory structure, which is incorporated by reference into the grant program, to the extent that it has very specific guidelines about what monies can be used for what aspects of church functions, is it your position that that doesn't help them here, or that we shouldn't be considering that as part of the case?
Well, it was stipulated at the trial court that the warning controlled.
Controlled what?
Controlled as far as, that's what was put before the town voters, that's what the court was looking at in their analysis, as far as I believe, as my understanding of it was. And that is very broad. It's too broad to prevent an injury. The town mentioned in their argument that this is regulated, that invoices must be presented, but at that point, the harm is already done if you're to the point of presenting invoices for these work.
Is the stipulation that you're referring to, was that on the record, so I'll find it in the transcript, or was that a written stipulation that would have been filed but maybe isn't in the printed case? Or
It
did I
was
miss
on, it would be within the transcript of the
So
the hearing.
it was on the record?
Yes.
Okay, thank you.
Is it your view that any expenditure of town funds that facilitates worship is constitutionally prohibited?
That, yes, that facilitates worship, I would definitely say is constitutionally prohibited. The diff-
Let me give you a hypothetical then. We have a very popular person in the town of Cabot who dies. And there's going to be a huge turnout at the funeral, which happens to be at the Cabot United Church. The town manager, or the select board, or whoever it is, says, you know, there's going to be a lot of people in the parking lot. We want the town constables to go down there and direct the traffic so these people can get in and out of the church safely. And they're in the church parking lot, not out on the street, in the church parking lot. Maybe they're helping handicapped people into the church, and they're being paid by the town. Is that unconstitutional?
I think that's more nuanced, and Chittenden somewhat got at that, saying that things such as transportation to a school, if we're talking, there's not as much of a difference between providing transportation to a religious school and transportation to a public school. I think this is falling in a similar area, but the thing that makes this case unique is that we're not dealing with the school, we're dealing directly with the church, and no matter what ancillary functions it may be put to, its essential nature is a church, is a place of worship that people go week in and week out, that was first built as a church, as this house of worship.
So what do you think? Can they do it or not?
No.
But as in American Atheists, Inc. versus Detroit, the court was talking about no reasonably informed observer would infer from the church's participation in the revitalization program, alongside and on equal terms with dozens of other secular entities, that the agency, by bestowing the grant, endorsed or approved of the church's religious views. Just distinguish that case as far as it was a revitalization effort of the downtown area. These grants, anyone can apply for them, and in this case, it's for repairs to a building. It happens to house a church, but just helping a building owner repair its building, does that necessarily violate any constitutional prohibition against requiring participation in the religion?
I think the main distinction between American Atheist is that it started with a geographic area that was set by completely neutral criteria, completely separate from religion. It was just sort of happenstance that a church fell within that area. Here you have the church directly asking for money, and the town supplying town money for that purpose.
For the purpose of repairing a building, not necessarily supporting dissemination of a religious view.
Not dissemination, but the building is a place of worship, and the simple majority that voted in support at town meeting, which is all that is required, is compelling all those in minority to support that church. I think for the same reason that the Council of Censors had issue with the 1783 Ministerial Act that opened up for vote. And eventually it was repealed after several changes to attempt to make it sort of comply with constitutional requirements. It was still repealed because they were uncomfortable with the idea that a portion of the community could vote and by their voting compel the remainder to support. And that was a 2/3 vote that was required as opposed to a simple majority here.
If the state fire code required smoke detectors in the chapel, and the town gave smoke detectors to everybody who needed to have them. Are you suggesting that providing a smoke detector to the church would be unconstitutional because that is supporting worship?
If it were to everybody in the broadest sense, I'm not sure that it would be, because there's no preference at all, but here the church was chosen above other applicants.
Okay,
That's the reason why.
thank you very much. Thanks.
The appellant has 1 minute and 30 seconds remaining.
Just a couple of quick points here. First, just at the hearing below, the town meeting warning, there was no stipulation that this was the sole restriction on the funds. The stipulation was that the town meeting warning is valid, it is what it is, it's a notice, but there are several other steps in the process that restrict these funds before they go to the church and before they could possibly go to any strictly religious element and support actual worship. Second point, at summary judgment below, the plaintiffs relied solely on taxpayer standing to the extent that they're raising some new form of standing based on the Compelled Support Clause. This is raised for the first time.
Well, didn't the trial court sort of raise that by its own analysis?
The trial court imported principles of Flast v. Cohen.
Right.
But that is an exception that was made through the First Amendment, but there is no corollary as.
So let me ask you, if let's say we conclude there is standing, but you win on the preliminary injunction. Let's say that we conclude that this is not irreparable harm, it can be remedied, in money. What happens next? Have you done everything you need to do to tee up the actual real merits decision instead of the substantial likelihood of the merits analysis?
No.
So what happens next?
So, next, I actually don't believe there's been an answer filed. We are at the very, very beginning stages here, and we would have to have, discovery and go through the whole process.
Okay.
Thank you.
Okay, thank you.
The next hearing for the court will follow immediately.